All right. State your name for the record, please, sir.
Darren Demetrius Martin.
Mr. Martin, I'm Judge Murphy. Do you agree to see me by video?
Yes, sir.
Okay. Your address is 1304 Evergreen Street in Anderson. Is that correct?
Yes, sir.
You're charged with murder, sir, and possession of a weapon during a violent crime, if not also sentenced to life in prison. Murder charge is a felony. If you are convicted, the penalty can be death or life imprisonment, which means for your natural life, okay, but no less than 30 years. So it can be a death sentence or 30 years to life. You understand?
No, I don't. You said possession of a weapon. They ain't got no weapon off me.
Okay.
What a weapon is.
Well, that's what trials are for, sir. Okay? You can use that as a defense, but that's what your charge is. And the charge is based upon probable cause presented by an officer to the issuing magistrate. Probable cause is a much lesser standard than guilt beyond a reasonable doubt.
Yes, sir.
Okay? But I'm not trying your case here today. This is a bond hearing.
I understand that, sir.
Okay.
I understand that.
Okay. All right. The other charge, possession of a weapon during a violent crime, is also a felony. If you are convicted of that charge, it is 5 years in prison in addition to any other sentence that you may receive, except, of course, the life sentence. If you get a life sentence, there's obviously not going to be another 5 years. Do you have any questions about those sentences, sir?
I have a lot of questions, but ain't a damn thing I can do about it.
All right, sir.
Go to trial on it.
Well, yes, sir, you can do that. And I'm going to let the use of the word damn go this time, but I do not need that anymore.
Yeah, I'm sorry about that.
You are in a court.
I'm sorry about that.
All right. Thank you, sir.
I'm sorry about that.
Okay. You're scheduled to appear in General Sessions Court on these charges on March 13, 2020 at 9 o'clock in the morning. This is not your trial time. This is the sign-in date with the solicitor's office. If you fail to make this appearance or any other required appearance, sir, a bench warrant can be issued for your arrest and you will be returned to jail. Now, understand that if you are still incarcerated at that time, that failing to make that appearance is not going to count against you because you're already incarcerated. Do you understand? Okay, I need yeses or nos. We're not videoing. This is on video, but I'm on the audio recording. Okay? All right, sir. When the time comes for you to be tried on this charge, you have the right to plead guilty and the right to plead not guilty and request a jury trial or a trial by the judge. You also have the right to be represented by a lawyer. And if you cannot afford to hire a private lawyer, you can get a public defender if you qualify financially. Now, it says here on the sheet that you are unemployed. Is that correct?
Yes.
Okay, then you will have no trouble qualifying for a public defender. Please also understand that while you are incarcerated, you automatically qualify for a public defender. Now, what you need to do to get a public defender while you are incarcerated is that you need to get listed on the kiosk when the public defender sends somebody through every day to see the new people, and you need to make sure that you get seen. Do you understand? Is that a yes?
Yes.
Okay, thank you.
Yes.
Now, if you are released on bond and they represented you while you were in jail, they no longer represent you once you are out of the detention center. Until you go to the Anderson County Courthouse, you pay the $40 referral fee at the clerk of court's office, and if you qualify financially under the federal poverty guidelines, then the public defender will be appointed to represent you. They will send a letter to your Evergreen Street address giving you the name of the lawyer assigned to your case and requiring you to make an appointment to see that lawyer to get the process of representation begun. Now, do you understand?
Say it again, sir. I didn't hear that last part.
To get the process of representation begun. You get to see you get a public defender while you're in jail. You get a public defender when you're out if you apply. I don't know who they would assign. I presume they would assign the same person, but you would still need to make an appointment to see them. Those are their rules, okay?
Yeah.
So if you get out of jail on a bond, you must go to the clerk's office to apply for the public defender's services. You understand that?
Yes, sir.
Okay. Do you have any questions? I'll be glad to answer them, sir. I cannot give you legal advice, but I can give you information concerning the processes.
I understand that, sir. But I own a lot of this stuff, and I just can't get to it.
I'm sorry, I'm not sure I understand that. What are you trying to?
What I'm saying is, I own a lot of this property around here,
What?
and
You own a lot of this property around here?
yes,
Okay.
and
Well, right
when
now.
they came to my house,
Okay,
came to my house,
Please stop, sir. Stop. Number one, I've not finished giving you your legal rights. I will give you the opportunity to speak at a later time during this hearing. Number two, you are being recorded, so anything you say could be used against you in court. Do you understand that?
yes,
Okay. Why don't you let me finish giving you your legal rights, and then we'll proceed with talking about whatever you feel the need to talk about. However, if at any point in time you do not understand the legal rights that I give you, I will be more than happy to explain them, as I have done with regard to the obtaining a lawyer. Do you understand?
all right.
Okay, thank you. Now, sir, you have an additional right on both of these charges to a preliminary hearing. Do you know what a preliminary hearing is?
Yeah, yes, sir. Yes, sir.
I tell you what, I'm going to explain it anyway. You must request your preliminary hearing in writing within 10 days, or you lose that right. There's a form with your bond paperwork that you can use requesting the hearing by signing it and either mailing it back to us at the address on the form, or you can sign it and give it to a detention officer, and they will get it back to us and your hearing is requested. Preliminary hearing is a hearing in front of a magistrate such as myself for the purpose of the state presenting sufficient evidence for the court to determine whether or not there is probable cause that you committed these crimes. Remember, I told you, probable cause standard is a much lesser standard than guilt beyond a reasonable doubt, which is what is required at your trial.
Yes.
If probable cause is found, then the matter is sent to the grand jury for indictment and subsequent prosecution. If probable cause is not found, then the matters are dismissed. But under the law of South Carolina, a solicitor can still take a case to the grand jury for indictment and subsequent prosecution, even after dismissal by the magistrate. Do you understand?
Yes.
Okay. Please remember, you have 10 days to make this request. And I will tell you that lawyers typically make this request, and it's certainly not going to hurt you to make the request. You can always at a later time decide that you don't want it if your lawyer wishes not to have it. But if you wait till later to ask for it, you cannot get it after 10 days. Do you understand?
Yes.
Okay. Do you have any questions about any of the rights that I've given you? Sir?
Whatever you're gonna hand down to me, just give it to me.
Okay. So you understand the rights that I've given you?
Yes.
Okay, thank you. All right, ma'am, do you wish to address me on the issue of the bond? I'll be glad to hear from you if you wish to. Okay. All right. The victim's mother is here. I have asked her if she wanted to speak to me on the issue of the bond. She does not wish to address me, so now I will ask you, sir. Remember, you're being recorded, so anything you say can be
Yes,
used
sir.
against you in court. Understand one thing, I, by law, cannot set a bond for you. It has to be done by a circuit judge. Your lawyer will have this pushed in front of a circuit judge as soon as possible for a bond hearing. But I can't give you a bond. There's no bond to deny. I do not have the authority to set a bond. Now, if you wish to say something, I will give you that opportunity, but that's your choice. But the bond hearing on this charge of murder will be held by a circuit judge. I do have the authority to set a bond on the other, but since they are connected to the same offense, they're all being sent up at the same time. There's no sense in me setting a bond here and then a circuit judge setting a bond on the other.
I don't understand it. I don't understand this. A murder case, I didn't kill nobody.
Okay. Well,
Okay, in possession of a gun, you didn't get no gun off of me. This shit is bullshit right here, man.
All right,
And them
sir.
people, I don't know them people right there. And I
Sir.
done told them people to stop coming to my house, man.
All right,
I don't
sir.
understand this shit right here, man.
all right, sir.
I ain't gotta stop talking.
Yes, you are. You're not going to do any more cursing in my court. Do you understand?
Man, I'm charged with murder, man.
Yes, sir. I understand that.
I'm charged with murder. I ain't killed nobody.
Okay.
Judge Murphy, did you let him sign anything?
He can go ahead and sign for the rights I've given him. You need to understand, sir, you're going to have to deal with this as a defense, and you need to talk to your lawyer about this. I strongly
Well, give me the paper
recommend.
before I can do all this.
I strongly recommend that you get a lawyer. Okay. Now,
I got the money to get the lawyer. I got the money to get the lawyer. I
then you
just
can
can't
get a
get to
private
it.
lawyer. Okay.
So what now?
I said then you can get a lawyer. What I would suggest is that you make sure that you speak to a public defender, and then you can go from there. All right, sir? Now, given the circumstances, I'm not going to waste time with a
I'm not
contempt
pleading
court
guilty nothing. I ain't
citation,
killed nobody.
but I am finished with you for this hearing, sir. They will show you where to sign. Just listen to the officer and sign where it says to sign, please. Thank you very much. You still recording or are you off? Fine. Process at this point is he's going to sign various places and initial various places.
All these people trying to act like me. You ain't acting like me.
In writing, he's getting what I have told him orally. All right.
Now y'all give me some paperwork for the public defender. You get that once you get the signing stuff and the paperwork come back. It'll be a couple hours.
Part of the paperwork you're seeking for the public defender, sir, is part of what you're signing. What you're signing is, in writing, everything that I've given you by way of your legal rights and other advice concerning the cases I'm required to do. Again, make sure that you get your name on the kiosk for somebody from the public defender's office to see you while you are in jail. And they can at least start the process of trying to get a bond for you. All right. All right.
You might well hold on to that pen. You still got several signatures to sign. So, yeah.
You all do not have to stay any longer if you wish. Okay. All he is doing is signing. You may want to stay and see if there's anything else he wants to say. But if you wish to leave, you're certainly welcome to. You're not required to stay. I thank you for your attendance. I do hope that you will attend when they do schedule a bond hearing for him with the circuit judge. But as I said, keep in touch with Ms. Rice.